We'll do that at the end of some person asking questions. Senator Coons.
Thank you, Chairman Grassley. Welcome, Senator Sessions. Congratulations to you and Mayor and your whole family on your nomination. The position of Attorney General of the United States is one of the most important positions on which this committee will ever hold hearings. And the next Attorney General of the United States will assume leadership of the Justice Department on the heels of an election in which there were many issues thrown about in the course of the campaign, some of which have been asked about previously. Calls for a Muslim ban or patrols, issues of a potential Russian cyber attack affecting our democracy, calls for mass deportations, and chants at some rallies to lock her up for one of the candidates. And given the divisiveness of this election, I think it is critical that the next Attorney General be well suited for this position and this time. And as such, I think a successful nominee has to be able to persuade this committee that he will act fairly and impartially administer justice and advance justice for all Americans. Senator Sessions, we've served on this committee together for 6 years, and we've worked well together on a few issues, on state and local law enforcement issues, on the reauthorization of the Victims of Child Abuse Act, and on the restoration of funding for federal public defenders, and I appreciate that partnership. But there's also been many issues on which we disagreed, issues from immigration to civil liberties to civil rights to criminal justice, voting rights, and torture. And I am concerned about your views on a number of these issues, as we discussed when we met last week. So I am grateful to the chairman and to you that we're going to have a full and fair hearing on all of these issues today. Let me start with some questions about your time when you were Alabama Attorney General and how you understood some direction you received from the U.S. Department of Justice. At that point, Alabama was the only state in the country that handcuffed prisoners to hitching posts. And we talked about this when we met before, and I said I would ask you about this in this hearing. A hitching post was used as a punishment for prisoners perceived as being unwilling to work or participate in the daily lives of the prison, whether serving on a chain gang or participating in work. And they would be cuffed by both wrists to a pole at chest height, sometimes for 7, 8, or 9 hours, unprotected from sun, heat, or rain, without access in some cases to water or even a bathroom. And as the Attorney General, you and the Governor received letters from the U.S. Department of Justice telling you that Alabama's use of the hitching post in both men and women's prisons was unconstitutional and unjustified. But as I understand it, the use of the hitching post continued throughout your term, and you did not act to stop it. During this same period, the state of Alabama was sued not just about hitching posts, but also about chain gangs. Prison policies in Alabama said a man could be put on a chain gang if he failed to shave or keep his bed clean, if he disrespected a member of the staff, and would end up doing hard labor breaking rocks while being chained together in groups of 5, shackled with 8 feet of chain between men. And these practices, the case that was brought demonstrated, were disproportionately affecting African Americans. In later litigation, the practice of using the hitching post was called by an Alabama judge the most painful and torturous punishment in Alabama, short of electrocution. And in 2002, the United States Supreme Court said using the hitching post was clearly unconstitutional when it was used in Alabama. Can you please, Senator, tell me your view today of the use of the hitching post and chain gang in Alabama corrections, and what your view is of what action you would take today if these practices were restored?
Thank you very much, Senator. That was an initiative of the governor who campaigned and promised that prisoners should work, and he was determined to make that happen. I believe the litigation occurred after my time as Attorney General, according to my records, but we could be wrong. I'll supplement the records for you. Certainly the decision by the Supreme Court and the federal courts were after I left office, I believe. So working of prisoners is an issue that we've dealt with in the Congress of the United States and by state legislatures. I think good employment of a prisoner is a healthy thing. I do not favor personally this kind of work. I think it should be more productive work that kind of help the individual develop a discipline that they could use when they go on to private life after they leave prison. After the Supreme Court ruling, I think it's crystal clear what the law is. That was disapproved and disallowed and found to be unconstitutional, and I would absolutely follow that as Attorney General.
In your view, did it take a ruling by the U.S. Supreme Court to clarify that this constituted torture, that it was not just bad corrections policy, it was actually substantively torture of prisoners?
Senator Coons, I don't recall ever personally being engaged in the studying of the constitutional issues at stake. It's perfectly legitimate for prisoners to work, but they should be on decent conditions, and I think it should be the kind of work that's productive and it could actually lead to developing good habits. I've heard some evidence on that subject, so I do not have a legal opinion about the case. Have not studied the details of it.
Just to be clear, what I was pressing you on there was the use of the hitching post, which is a disciplinary measure that had been abandoned by all states but Alabama. It's really reminiscent more of the stockade that was used centuries ago, and to me somewhat troubling that it continued without challenge. Let me ask you more broadly. As you know, both Republicans and Democrats on this committee have worked together to address ways in which our criminal justice system is broken and to address the disparate racial impact of over-incarceration that's resulted in the last 30 years. Senator Tillis and I just yesterday published an op-ed that we wrote jointly about the importance of responsible, balanced criminal justice reform, and Senators Grassley and Cornyn, Lee, and Graham and Flake, all your fellow Republicans, have supported meaningful reforms to address excessive mandatory sentences and incarceration. And in my experience here in 6 years with you, you have steadfastly opposed all of these efforts at bipartisan sentencing reform. Help me understand why you've blocked efforts at reducing mandatory minimum sentences, at creating opportunities for the revisitation of sentences that may have been overly harsh when initially imposed, and help me understand whether you think it is ever proper for a prosecutor to charge anything less than the most serious offense available and carrying the longest sentence.
Well, there's a lot of questions there,
yes,
Senator Coons. So the Sentencing Act has one foundational requirement now, and that's the minimum mandatories. The guidelines have been either made voluntary by the Sentencing Commission and the courts and the policies of the Attorney General. So the thing that does stand in place are the minimum mandatories, the minimum that can be sentenced for a certain offense. I offered legislation in 2001. It was opposed by the Bush Justice Department that would have reduced the sentencing guidelines, and in fact, a number of years later, unfortunately, essentially could have been done in 2001. When I made a speech in favor of it, made a speech saying what you are saying, that it was disproportionately impacting our African-American community, and we needed to fix it, and eventually that was passed. So I have a record of doing that, number one. Number two, so these other things happened in the meantime. The guidelines were reduced. The Justice Department has reduced its requirements. The Justice Department now allows a prosecutor to present a case to the judge that doesn't fully reflect the evidence that they have in their files about a case. That's a problematic thing. You shouldn't charge, I think, it's problematic and difficult to justify a prosecutor charging 5 kilos of heroin when the actual amount was 10, to get a lower sentence. Now, there may be circumstances when somehow proof and other issues could justify that, but I just would say, as a principle, you got to be careful about it. Finally, colleagues, sentencing guidelines are within the breast of the Congress. They're mandated by law. I was concerned about what we're seeing is beginning to see a rise in crime, and at the same time, a decline in sentences. Sentences are down 19% already, as based on Sessions, Durbin, and guidelines changes. So that's a matter of interest. And I felt we should slow down a bit before we go further.
Well, if I might,
make
Mr.
sure we're not making a mistake, Senator Coons.
It is my hope that if you are confirmed and we do make progress on bipartisan criminal justice reform, that as Attorney General you will carry out whatever legislative decisions might be made by this body. Last, let me just say that in my 6 years here, in addition to not working with us on a number of bipartisan proposals on criminal justice reform, you've been one of the few senators to repeatedly and steadfastly vote against congressional attempts to prohibit torture in the military context or in the interrogation context, and to repeatedly defend enhanced interrogation practices. Are you clear now that our statutes prohibit torture? And if the President were to attempt to override that clear legal authority, what actions would you take? On your previous question, I would note that federal prison population has already dropped 10 or more percent and will drop another 10,000 this year. So what's happening now is reducing the federal population. This law only dealt with the federal prison population, and that represents the most serious offenders. Our federal DEA and U.S. attorneys are prosecuting more serious cases. With regard to the torture issues, I watched them for some time and have been concerned about what we should do about it. This bill that passed last time was a major step. I thought it was really not the right step. Senator Graham, I know, has been an opponent of torture steadfastly and supported a lot of different things, opposed it. It basically took what I was teaching the young soldiers at the Army Reserve Unit as a lecturer, as a teacher, the Army Field Manual, and it made that the law for the entire government, including the intelligence agencies and other departments. I thought that was an unwise step to take something that directs even the lowest private to do, to make that the rule for higher ups. Well, but it's the law. It is a law, and it needs to be enforced, absolutely. As we both know, there was a bipartisan effort to review our experience with enhanced interrogation.
It was, but
it was not effective.
Yeah, it was, and of course Senator Graham's a JAG officer, as I was for a little bit.
Thank you, Mr. Chairman. Senator Sessions, congratulations on your nomination.
Thank you.
You are a friend. You are a man of integrity. You and I have worked closely together on this committee, on the Armed Services Committee, and I have every confidence you are going to make a superb Attorney General. You know, this has been an interesting day at this hearing, listening to Democratic senator after Democratic senator give speeches in praise of the rule of law. And I am heartened by that. I am encouraged by that. Because for 8 years it's been absent. For 8 years we've seen a Department of Justice consistently disregarding the rule of law. When Eric Holder's Department of Justice allowed illegal gun transactions, illegally sold guns to Mexican gun traffickers as part of Fast and Furious, guns that were later used to murder Border Patrol agent Brian Terry, the Democratic members of this committee were silent. When Eric Holder was found in contempt of Congress for refusing to cooperate with Congress's investigation into Fast and Furious, once again the Democratic members of this committee were silent. When the IRS illegally targeted United States citizens for exercising their First Amendment views, for exercising their roles in the political process, Democratic members of this committee were silent. When the Department of Justice refused to fairly investigate the IRS targeting citizens and indeed assign the investigation to a liberal partisan Democrat who had given over $6,000 to President Obama and Democrats on this committee were silent. When numerous members of this committee called on the Attorney General to appoint a special prosecutor to ensure that justice was done in the IRS case, Democrats on this committee were silent. When the Justice Department began using Operation Choke Point to target law-abiding citizens that they disagreed with politically,
Senator Sessions, you are racist. You are tied to the KKK. You want to be an organization.
free speech is a wonderful thing. When the Department of Justice used Operation Choke Point to target legal businesses because they disagreed politically with those businesses, the Democrats on this committee were silent. When the Obama Justice Department sent millions of dollars of taxpayer monies to sanctuary cities that were defying federal immigration law, the Democrats on this committee were silent. When the Obama administration refused to enforce federal immigration laws and unilaterally rewrote those laws, the Democrats on this committee were silent. When the Obama administration released tens of thousands of criminal illegal aliens, including rapists and murderers, into the general population, Democrats on this committee were silent. When the Department of Justice signed off on the Obama administration paying a nearly $2 billion ransom to Iran, contrary to federal law, the Democrats on this committee were silent. When the Obama administration ignored and rewrote provision after provision of Obamacare, contrary to the text of the law, the Democrats on this committee were silent. When the Obama administration signed off on illegal recess appointments that the Supreme Court had to strike down unanimously, the Democrats on this committee were silent. And when the Obama administration released 5 Guantanamo terrorists without the required notification of Congress, the Democrats on this committee were silent. That pattern has been dismaying for 8 years, but I take today as a moment of celebration. If once again this committee has a bipartisan commitment to rule of law, to following the law, that is a wonderful thing, and it is consistent with the tradition of this committee going back centuries. Now, if we were to play a game of tit for tat, if what was good for the goose were good for the gander, then a Republican Attorney General should be equally partisan, should disregard the law, should advance political preferences favored by the Republican Party. Senator Sessions, do you believe that would be appropriate for an Attorney General to do?
No, I do not. I believe you, and I think we do have to be aware that when something like this is done, and some of the things I'm familiar with enough to agree with you that I thought were improper, I do believe it has a corrosive effect on public confidence in the constitutional republic of which we are sworn to uphold.
I think you are exactly right. You and I are both alumni of the Department of Justice, and it has a long bipartisan tradition of staying outside of partisan politics, of simply and fairly enforcing the law. I will say right now, if I believed that you would implement policies, even policies I agreed with contrary to law, I would vote against your confirmation. And the reason I am so enthusiastically supporting your confirmation is I have every degree of confidence you will follow the law faithfully and honestly. And that is the first and most important obligation of the Attorney General. Now, earlier in this hearing, Senator Franken engaged you in a discussion that I think was intended to try to undermine your character and integrity. And in particular, Senator Franken suggested that you had somehow misrepresented your record. It is unfortunate to see members of this body impugn the integrity of a fellow senator with whom we have served for years. It is particularly unfortunate when that attack is not backed up by the facts. Senator Franken based his attack primarily on an op-ed written by an attorney, Gerald Hebert. There is an irony in relying on Mr. Hebert because, as you well know, in 1986, during your confirmation hearing, Mr. Hebert testified then and attacked you then, making false charges against you. And indeed, I would note in the 1986 hearing, 2 days later, Mr. Hebert was forced to recant his testimony, to say that he had given false testimony to this committee, and indeed to say, quote, "I apologize for any inconvenience caused Mr. Sessions or this committee by my prior testimony." So an individual who's testified falsely once before this committee, his op-ed is now the basis for Senator Franken's attack on you. And indeed, the basis of Senator Franken's attack is he claims you were uninvolved in several civil rights cases that were listed on your questionnaire. In 1986, Mr. Hebert testified, this is a quote from him, "I have needed Mr. Sessions' help in those cases, and he has provided that help every step of the way." Is that correct, that that's what Mr. Hebert testified?
Yes, that's correct.
supported all 4 of them in your supplement to the Judiciary Committee. Is that right?
That is correct.
Mr. Franken didn't mention that. And let me point out, here's how you describe your involvement in your written submission to this committee. Quote, for the cases described in 2, 4, 8, and 9, my role, like most U.S. attorneys in the nation and with non-criminal civil rights cases, was to provide support for the Department of Justice, Civil Rights Division's attorneys. I reviewed, supported, and co-signed complaints, motions, and other pleadings and briefs that were filed during my tenure as U.S. Attorney. I provided assistance and guidance to the civil rights attorneys, had an open-door policy with them, and cooperated with them on these cases. For the cases described in 6, I supervised litigation and signed the pleadings. Now, that is consistent with the 1986 testimony that you provided help every step of the way. Is that correct?
Well, I think so, yes.
There's no question you've been forthright with this committee, and I would note that members of this committee don't have to search far and wide to know who Jeff Sessions is. We've known every day sitting at this bench alongside you. I want to shift to a different topic, and it's the topic I opened with, which is the politicization of the Department of Justice. The Office of Legal Counsel has a critical role of providing sound legal and constitutional advice, both to the Attorney General and the President. And in the last 8 years, we have seen a highly politicized OLC, an OLC that has given politically convenient rulings, whether on recess appointments, whether on executive amnesty, and early on, perhaps that was started by 2009 Attorney General Holder overruling OLC concerning legislation trying to grant the District of Columbia representation in Congress. And it may well be that that sent a message to OLC that its opinions were to be political and not legal in nature. Tell me, Senator Sessions, what will you do as Attorney General to restore professionalism and fidelity to law to the Office of Legal Counsel?
Senator Cruz, I think any short-term political agenda gains that come from the abuse of the lawmaking processes and requirements of the Department of Justice just don't make sense. It will always, in the long run, be more damaging than the short-term gain that one might have. The Office of Legal Counsel, all of us who served in the department know, is a big-time position. You need a mature, smart, experienced person who understands this government, who understands the laws, and is principled and consistent in their application of the laws. That will help the President, it will help the Congress, and it will help the American people. I do believe we need to work hard to have that, and I will do my best to ensure we do have it.
One final question. In the last 8 years, the Department of Justice's Solicitor General's office has also, I believe, been unfortunately politicized, and it sustained an unprecedented number of unanimous losses before the United States Supreme Court. Indeed, President Obama's Justice Department won less than half of its total cases before the Supreme Court, which is the lowest presidential win rate since Harry Truman. The average historically for the last 50 years has been about 70%. Numerous of those cases were unanimous, with indeed both Obama Supreme Court appointees voting against the lawless positions of this Justice Department, including their assertion that the government has the authority to supervise and direct the appointment and the hiring and firing of clergy in the church. What will you do as Attorney General to ensure the integrity of the Office of Solicitor General, that it is faithful to the law and not advancing extreme political positions like the Obama Justice Department did that have been rejected over and over again by the Supreme Court?
I think the problem there is a desire to achieve a result sometimes that overrides the commitment to the law. In the long run, this country will be stronger if we adhere to the law, even though somebody might be frustrated in the short term of not achieving an agenda. The Solicitor General should not advocate to alter the meaning of words to advance an agenda. That is an abuse of office, and I would try to seek to have a Solicitor General who is faithful to the Constitution, serves under the Constitution, does not feel it has the power to rise above it and make it say what it wants it to say.
Thank you, Senator Sessions.
Your Blumenthal goes, I think we have votes still scheduled for 2:45. It's my idea that we would continue this going, like I'll go with, and then vote and come back, and I hope other people will preside and keep asking questions while the two votes are going on, so we can finish at a reasonable time today.
What about Sessions voting?
What?
He's not voting.
Okay. Well, that's right. Did we get a decision? You can stay here during that voting part. Senator Blumenthal.
Thanks, Mr. Chairman, and thank you for conducting this hearing in such a fair-minded and deliberate way. And I want to join you in thanking Senator Sessions for his public service over so many years, and his family, who have shared in the sacrifices that you have made. So I am sure that my colleagues and I appreciate your service and your friendship. This experience for us is a difficult one, not only because you're a colleague, but I consider you to be a friend and someone who is well-liked and respected in this body, understandably. And I know if you were sitting here, you'd be pretty tough on me, maybe tougher than I'm going to be on you. Kinds of tough questions. You and I have shared some experiences. Both of us have been United States attorneys and attorneys general of our state, and I want to thank you as well for thanking our law enforcement community, which is so important to this nation. And it makes sacrifices, and those sacrifices often are not only in time and foregone income, but also in lives. And I join you in respecting the law enforcement officers who were victims most recently of gun violence. I want to begin just by asking you a question which I asked in a letter. Will you recuse yourself from voting on your own nomination and the nominations of other cabinet secretaries?
I do not have plans to vote on my nomination. I have not thoroughly examined all the issues, but I think there could be a conflict of interest or a violation of the ethics rules, and I would comply with the rules.
I believe it would be a conflict of interest for you to vote on other cabinet secretaries, as they are nominated by the president, who is also your boss, and I think that I hope you will consider recusing yourself from those votes as well, because I think it will set a tone for what you will do in cases of conflicts of interest. And I want to talk a little bit about conflicts of interest, because I think that the Attorney General of the United States has a unique and special role, especially at this point in our history. He should be a champion, a zealous advocate of rights and liberties that are increasingly under threat in this country. And he's not just another government lawyer or another cabinet secretary. He is the nation's lawyer. And so any appearance of conflict of interest or compromising positions because of political involvement, I think, is a real danger to the rule of law and respect and credibility of the rule of law. So I would hope that you would consider appointing special counsel in cases where there may be a conflict of interest involving the president. And one of those cases involves Deutsche Bank. The President of the United States owes Deutsche Bank several hundreds of millions of dollars. It's currently under ongoing investigation. Will you appoint an independent counsel to continue the investigation of Deutsche Bank?
Well, Senator Blumenthal, I'm not aware of that case. I'm not in any way, have not researched it or even read some of the published articles about it, so I'm totally uninformed about the merits or lack of it of the case. I don't know that the president is implicated. It's simply because he's borrowed from a bank. But I would say that, as Senator Lee, I think, raised in his questioning, you don't want to be in a position where every time an issue comes up, the Attorney General recuses himself, but at the same time, serious questions, when they arise, the Attorney General should recuse himself on the appropriate circumstances. And I guess that goes with the appointment of a special counsel, which is a somewhat different issue. There's been a lot of criticisms of that, but I think it's a useful tool in the appropriate circumstances.
Would you agree with me that the Emoluments Clause applies to the President of the United States?
Well, the Emolument Clause applies. I guess the dispute is, and the discussion is to what extent does it apply, and how does it apply in concrete situations,
if
which
there's
I have
evidence,
not studied.
If there's evidence that the President of the United States has violated or may be violating the Emoluments Clause, will you appoint a special counsel?
We would have to examine that. I would not commit to this day, at this time, of appointing a special counsel when I'm not aware of a precise factual situation that would be in play.
If there is a violation by the President's family of the Stock Act, which prohibits the use of private or insider information for personal gain, will you apply special counsel?
Well, we'll have to evaluate that if such a circumstance occurs, and I would do my duty as I believe I should do it at the time.
I would suggest that in those cases, an independent counsel is not only advisable but required to avoid a conflict of interest, and I would hope that you would be sensitive to those concerns.
Well, there are reasonable arguments to be made for that. I suggested that Attorney General Lynch should appoint a special counsel in the Clinton matter. I don't know whether you supported that or not.
One reason I'm asking the question is that you have advocated a special counsel in other instances where, in fact, the argument for it was weaker than it would be in these cases, and I think it would be appropriate. Well,
I will suggest that during a campaign, sometimes we get excited, but as Attorney General, you have to follow the law, you have to be consistent, and you have to be honorable in your decision-making, and I respect the questioning you're raising.
Let me ask you about another group. I welcome your condemnation of the Ku Klux Klan. You may be familiar with a group called Operation Rescue. And Operation Rescue endorsed you. In fact, Troy Newman, the head of Operation Rescue, said, quote, "We could not be happier about the selection of Senator Jeff Sessions as the next Attorney General." Operation Rescue has, in fact, advocated, quote, "execution," end quote, of abortion providers. And as an example of its work, this poster was circulated widely in the 1990s and early 2000s about a Dr. George Tiller, who subsequently was murdered. After his murder, Operation Rescue said that his alleged murderer should be treated as a political prisoner. Dr. Tiller was murdered in 2009, and I'm sure you're familiar with this case. Will you disavow their endorsement of you?
I disavow any activity like that, absolutely, and a group that would even suggest that is unacceptable. And I will enforce the laws that make clear that a person who wants to receive a lawful abortion cannot be blocked by protesters and disruption of a doctor's practice. I might not favor of that. I am pro-life, as you know, but we've settled on some laws that are clearly effective, and as Attorney General, you can be sure we would follow them.
You would use the FACE statute, the Freedom of Access to Clinic Entrances Act, to empower and mobilize the FBI, the Federal Marshal Service, or the Bureau of Alcohol, Tobacco, and Firearms to protect clinics if there were harassment or intimidation?
I would use the appropriate federal agencies, and I do believe it is in violation of the law to excessively or improperly hinder even the access to an abortion clinic.
Will you rigorously enforce statutes that prohibit purchase of guns by felons or domestic abusers or drug addicts, and use the statutes that exist right now on the books to ban those individuals from purchasing guns?
Well, Congress has passed those laws. They remain the bread and butter enforcement mechanisms throughout our country today to enforce gun laws. The first and foremost goal, I think, of law enforcement would be to identify persons who are dangerous, who have a tendency or have been proven to be lawbreakers and been convicted, and those who are caught carrying guns during the commission of a crime. Both of those require mandatory sentences. As United States Attorney in Alabama, it was a high priority of mine. I calculated a number of years. We were one of the top, even though a small office on a percentage basis, we were one of the top prosecutors of those cases. I think it saves lives, Senator Blumenthal. As a matter, my judgment at least, as experience tells me, it can help create a more peaceful community.
Will you support laws necessary to effectively apply those laws, including universal background checks that are necessary to know whether the purchaser is a felon or a drug addict or a domestic abuser?
Well, I believe in background check laws, and many of them are appropriate, but in every instance, there are some instances when it's not practical. Like, say, for example, somebody inherited a gun from their grandfather. Those transactions, I'm not sure, should require that kind of universal background check.
Member of this committee, Senator Crapel, welcome to the committee, and you may proceed.
Thank you, Mr. Chairman, and I too want to thank you for the way you are handling this hearing and appreciate your service here in the committee. And Senator Sessions, I also want to join those who have congratulated you on your nomination to be the Attorney General of the United States. I am one of those who has had the opportunity to work with you for years and know you very well. I consider you well qualified and look forward to your service as Attorney General of the United States, if you are confirmed, and I expect you will be. I know you to be a man of your word. I know that you're committed to the Constitution of the United States of America, and you are committed to enforcing the law of this country, as you have said multiple times here in this committee. So I thank you for that. I want to go in my questions into just a couple of other areas beyond just the notion of the enforcement of the law, but the manner in which the Department of Justice enforces the law. Three basic areas. One, the abuse of the power or discriminatory enforcement of the law. Two, regulatory overreach that we're seeing across this country, and what role the Department of Justice plays in trying to deal with that. And then finally, cooperation with the states. We live in a union of 50 states, and under our Constitution, there are appropriate roles for the federal government and the states, and the Department of Justice has a very powerful influence on that. So if I could get into those three areas. The first one I'm just going to use as an example of the kind of abusive use of power that I hope you will help stop and prevent from continuing to happen. It was already, this example is one that was already referenced by Senator Cruz, Operation Choke Point. Operation Choke Point, for those that aren't familiar with it, the only appropriate thing about it, in my opinion, is its name. It was a program designed by the Department of Justice to help choke financing away from businesses and industries that were politically unacceptable or, for whatever reason, unacceptable to the administration. The Justice Department, working with, and I think perhaps even pressuring, some of our financial regulatory agencies, created this program to give additional scrutiny, indeed such aggressive scrutiny that it pressured them out of their access to financing to certain industries. I don't know how these industries got on the list, but I'll just read you several that are on the list. Ammunition sales, coin dealers, firearms sales, installment loans, tobacco sales. This list is a list of 30 that was put out by the FTC. When they actually realized they shouldn't have put the list out, they quickly took it back. And the FDIC says that they're not pursuing this program anymore. But when we tried to defund it earlier, the administration fought aggressively to make sure we didn't get the votes to defund it. This program is one where the justification is, well, the businesses who operate in these industries haven't done anything wrong. But these are industries that might do things wrong more than other industries. And therefore, we're going to pressure people out of these industries. It reminds me of a 2002 movie called Minority Report. It was a Tom Cruise movie, and that was one about an advanced police force in the future that had determined or had developed the ability to know if you were going to commit a crime before you commit the crime. And then their job was to go arrest you. It was really good at stopping crime because they arrest you before you even commit it. And then one of them came up on the list, and that's the story of that movie. My point is, we can't really tell for sure whether Operation Choke Point is still operating, although we still have people in these industries who can't get financing. If that kind of thing is going on in the Department of Justice, will you assure that it ends?
I will. At least as you frame this issue, and as I understand the issue from what little I know about it, but fundamentally, a lawful business should not be attacked by having other lawful businesses pressured not to do business with the first business. That's, to me, it would be hard to justify. I guess maybe they've got some arguments that would be worth listening to, but fundamentally, that seems to me, Senator Crapo, you're a great lawyer, but it seems to me that goes beyond what would be legitimate in a great economy like ours.
Well, I would hope the Department of Justice would not be a partner with any of our federal agencies in this kind of conduct. Another one which I'll throw out as an example is the National Instant Criminal Background Checklist, which is now being utilized by the Veterans Administration and by the Social Security Administration to put people's names on the list so that they can be denied access to owning or purchasing a firearm. And the way they put their name on the list is to say that they are mentally deficient. If they need a little help on their Social Security benefits, if they're a veteran who put their life on the line for us and goes to war and receives a head injury, and so they need a little bit of assistance, then they get their name often put on the list. I know that these are not the agencies that you supervise, but I know the Department of Justice supervises the NICS list. And I would just encourage your help, whether it's here or anywhere else in our government, as we see agencies using their power to achieve political purposes or some other discriminatory purpose of the administration, I would hope you would stand solidly against it.
Well, thank you, Senator Crapo. I know you've worked on that issue. So I'd be sympathetic and be willing to receive any information that I know you've gathered to form your views about it.
All right, I appreciate that. Let me move on to the question of regulatory overreach. I'll just use one example there. I'm one who believes that today we talked a lot in this hearing today about the rule of law. In America, statutes are passed by Congress and signed into law by a willing president. But now we have multiple agencies that are doing rulemakings that, in my opinion, are going far beyond the legal authority of the laws under which they operate. I'll use one example, the Waters of the United States rule that has been implemented or is seeking to be implemented by the EPA and the Army Corps of Engineers. In my opinion, that is totally unfounded in law. And often the Department of Justice is partnered up with these agencies as they try to defend their activities in court. And I'm not sure I actually know the proper role there. Does the Department of Justice simply have to litigate on behalf of these agencies? Or does it have the ability to advise these agencies that they are pursuing activities beyond the bounds of the law?
It can be that an agency would ask an opinion of the Office of Legal Counsel, the Department of Justice, and as to whether their interpretation is sound or not. That opinion, until reversed at some point, stands for the entire government. But basically, these agencies oftentimes just set about their own agendas without asking for an opinion. And often they are narrow-minded, or they're focused only on what they feel are the goals of their agency, and don't give sufficient respect to the rule of law and the propriety of what they're doing. In particular, did the Congress really intend this? Did this law really cover this, or is it just something you want to accomplish and you're twisting the law to justify your actions? Those are the kind of things that we do need to guard against.
Well, I appreciate that, and I hope that under your leadership, we will have a Justice Department that will give strong advice where it can and have strong influence where it can across the United States system, across our agencies in this country, to help encourage and advise that they stay within the bounds of the law. The last thing, and I'll just finish with this, and you can give a quick answer. I'm running out of time here, and that is cooperation with the states. As I said earlier, our system of government is comprised of 50 states in a union under a constitution that establishes a federal government. And you and I both know well that the 10th Amendment says that those rights and powers that are not specifically granted to the federal government in the Constitution are reserved to the states and to the people, respectively. Many of our states feel that that proper respect for their sovereignty is being abused, again, by federal agencies, not just the Department of Justice, but the Justice Department often gets involved in this through providing the legal services that it does to our agencies. And, you know, I could go through a ton of more examples and lists of litigation that is ongoing right now with my state and other states around the country, where if we simply had a better level of respect for the role of states in this union and under our Constitution, we could work out a lot more of these issues rather than having the heavy hand of the federal litigation system come to play into forcing compliance by states. And so I won't go into any specific details, but would just ask your feelings about that importance of respecting the role of states in this country.
There's no general federal criminal crimes. So many things like larceny and even murder unconnected to some civil rights connection, these things have traditionally been totally the responsibility of the states. As a young prosecutor in the 1970s, I remember almost all the cases had an interstate commerce nexus. It wasn't the theft of an automobile that you prosecuted. It was interstate transportation of a stolen vehicle.
A lot of
So a lot of that is just now we've forgotten that distinction, that limitation on federal power.
We have, and a lot of what I'm talking about happens in the Environment and Natural Resource Division or in others. There's a lot of litigation out there. I just encourage you. I am out of time.
Let me make a suggestion before I introduce Senator Ronald, and she's welcome back to the committee. She's been off 2 years. To make efficient use of our time, when she's done, it would be Senator Kennedy's turn, but you probably have to go vote. So if there's somebody back here that can start the second round, do it, and then we'll call on Senator Kennedy to finish the first round. Senator Ronald.
Thank you, Mr. Chairman. It's good to be back on this committee. And aloha to you, Senator Sessions.
Aloha.
I will do my best to be nice to you.
Well, that won't be hard for you.
Thank you very much. I know that the Attorney General has broad prosecutorial discretion. You noted in some of your responses to questions from Senator Durbin around the issue of what would happen to the 800,000 DACA registered people if the president-elect rescinds that program, and you indicated that I think at that point that the AG's office has only so many resources, and that may not be a high priority for you, but you indicated that's why we needed immigration reform. So my series of questions will center around how you would exercise your prosecutorial discretion, which I think you would acknowledge is wide as Attorney General, wouldn't you?
Okay. In many cases, you do, the federal prosecutors set discretionary limits, but you have to be careful that it does not exceed a reasonable judgment about what a discretion should be.
It's not totally unfettered, but why prosecutorial discretion? So my questions will center around how you would exercise prosecutorial discretion with regard to some specific issues. You probably know, Senator Sessions, that I am an immigrant, and you indicated in one response that you would want immigration reform to center around skills-based immigration reform. And if that were the case, my mother, who brought me to this country to escape an abusive marriage, would not have been able to come to this country, and she acquired her skills later, but I just want to let you know that this is one of the reasons that issues relating to immigration are very important, not just to me, but to millions of people in this country. And I have heard from them. I've heard from immigrants in this country, LGBT Americans, women, and religious minorities who are terrified that they will have no place in President-elect Trump's vision of America. And based on what I've heard since the election, I am deeply concerned that their fears are well-founded. I'm hoping that you can address some of these concerns today. So I mentioned the exercise of prosecutorial discretion. When you came to see me, we did talk about whether or not you would support a ban on Muslims coming to this country based on the fact that they were Muslims, and you said you would not support that. But you also indicated that you would support basically what would be considered enhanced vetting of people with extreme views. What would characterize an extreme view to you, and how would you go about ferreting out people with extreme views when there are millions of people legally coming into our country? And also a related question, the fact that you would consider vetting of people with extreme views to be a proper use of our governmental authority, there must be a connection in your mind that people with extreme views, which I hope you will describe what you mean by, will do something that would compromise the safety of Americans. Could you respond to my series of questions relating to extreme views?
Well, I do think, first of all, the vetting process is in the hands of the State Department, at the consular offices and those offices that are meeting people abroad and evaluating them for admission to the United States. So the Department of Justice really does not dictate that, as long as it's as long as it's within constitutional order. I think the approach that's preferable is the approach that would be based on areas where we have an unusually high risk of terrorists coming in, people who could be clearly violent criminals, and those certainly justify higher intensity of vetting. I think that maybe responds to your question, but again, the ultimate decision about that would be done through the State Department and by the President.
I'm sure they would ask for the Attorney General's opinion as to the limits of the Constitution in requiring these kinds of questions to be asked of people who come to our country. And you did indicate that one's religious views would be a factor in determining whether somebody has extreme views. Let me turn to...
If their religious views not in
and of itself.
Extremism, right. Not... if they, their interpretation of their religious views encompasses dangerous doctrines and terroristic attacks, I think they should certainly deserve more careful scrutiny than someone whose religious views are less problematic.
Yes, Senator Sessions, you did say that one's religious views would be a factor in determining whether one has extreme views that would enable, that would not enable them to come to our country. Let me turn to the question of abortion. On Roe v. Wade, you did say, quote, "I firmly believe that Roe v. Wade and its descendants represent one of the worst, colossally erroneous Supreme Court decisions of all time, and it was an activist decision." My question is, do you still hold that view? I believe you answered yes to someone who asked you that question previously, that you believe that Roe v. Wade was a bad decision.
Well, I did.
You still believe that?
Well, I guess I've said that before. It's, I'm a pro-life advocate, but fundamentally, the problem, as I see it, with Roe versus Wade is that it denies the people the right to make laws that they might feel appropriate. Did the Supreme Court have that power? I concluded they didn't, because the Constitution didn't answer that question. But
Senator Sessions,
I respect people.
I hate to interrupt you, but I have less than 2 minutes, so I don't want to get into the substance of Roe v. Wade. I realize you still believe that that was a bad decision, although it was based on constitutional privacy protections. So we can expect the makeup of the Supreme Court to change, and we can very well end up with a Supreme Court that will be very open to overturning Roe v. Wade. And should you be the Attorney General, would you direct or advise your Solicitor General to weigh in, weigh in before that Supreme Court, which has an opportunity to overturn Roe v. Wade? Would your Solicitor General go in and weigh in to repeal or to overturn, I should say, Roe v. Wade?
Well, Roe versus Wade is firmly ensconced as the law of the land, and I don't know we would see a change in that. You're asking a hypothetical question. Those cases seldom come up on such a clear issue. They come up at the margins. I just would not be able to predict what well-researched, a thoughtful response would be to matters that could happen in the future.
I think most of us know that the next opportunity for the Supreme Court to weigh in on whether or not to change Roe v. Wade would be a very close decision, and likely possibly a 5-4 decision, and that it's not just a hypothetical, but it is of real concern to a lot of people. Let me turn to the Voting Rights Act. While the Supreme Court did eliminate parts of the Voting Rights Act, it still retains Section 2, which prohibits states from enacting laws that would have a discriminatory impact. And the Attorney General's office was a party to challenging 2 states' laws. I believe it was Texas and there was another state, that the Supreme Court ultimately agreed with the Attorney General's position that these laws violated the Voting Rights Act, Section 2. Would you, should you become the Attorney General, just as vigorously prosecute those kinds of state laws that have a discriminatory voting impact?
Well, this administration's Attorney General has intervened when it felt it was appropriate and not intervened when it did not feel it was appropriate. So I think my responsibility would be to ensure that there's no discriminatory problems with a Voting Rights Act of a state. If there is, if it violates the Voting Rights Act or the Constitution, I think the Attorney General may well have a responsibility and a duty to intervene. You cannot allow improper erosion of the right of Americans to vote.
Well, we know that since the Supreme Court's decision that did away with major parts of the Voting Rights Act, that numerous states, perhaps 13 states, have already enacted laws that could be deemed contrary to the Voting Rights Act. So I would hope that as Attorney General, you would vigorously review those kinds of laws and to prosecute and to seek to overturn those state laws, just as your predecessors have done. I want to turn to VAWA. I know that you voted against the most recent iteration of VAWA because you had concerns about how the non-Indians would be prosecuted under tribal law. And you indicated that, yes, you do acknowledge that non-Indians do go on tribal lands, commit crimes, and that these kinds of crimes should be prosecuted at the federal level. And I would expect that should you become Attorney General that you will do that. But at the same time, my question is, would you then seek to overturn that part of VAWA that allows the tribal courts to proceed?
That would be a strictly legal decision. We should give respect to the laws of Congress that have been passed. As a member of Congress, I was uneasy with it, did not think it was a good approach, and I believe 8 out of 9 Republicans on the committee shared that concern and did vote against it. As I noted earlier, I voted for the Violence Against Women Act in 2000, yes. 2010, and I voted for the Grassley version of the Violence Against Women Act this past time, even though I did vote against the
So
version that became law.
as Attorney General, you would not do anything to challenge that part of VAWA that allows for tribal courts to proceed?
Well,
right?
I would have to make a legal decision on that. I'm not able to do so today.
Thank you, Mr. Chairman.
Thank you. Senator Sessions, as you're aware, in many instances, Congress, when enacting a law, will choose to issue a broad sort of mandate, a broad aspirational statement, leaving the details of the actual lawmaking process to a regulatory system that then has to follow certain procedures in turn to effectively make laws. We call those regulations, typically. And sometimes an executive branch agency will go a step further. And outside the process that has to be followed when promulgating a new regulation, they'll just issue a guidance document outlining what the agency feels is the status of the law in this area. Guidance documents have received a lot of criticism from members of the public who point out that they are bereft of any kind of safeguard and that they haven't gone through a legislative process. They haven't even gone through any type of review process that would normally accompany the regulatory rulemaking cycle. As a matter of policy making, will the Department of Justice, under your leadership, assuming you're confirmed, use guidance documents as a matter of course in promulgating legal interpretations?
Senator Lee, a guidance document that's clearly within the intent of Congress and the law's plain words can be beneficial. I think they're normally issued by the agency or department that administer it, like, for example, Health and Human Services, Homeland Security, Department of Commerce. Often or sometimes they ask the Office of Legal Counsel for their opinion about what the proper interpretation of a statute is. But I do think you raise a valid concern. A guidance document cannot amount to an amendment of a law. Bureaucrats do not have, that's a pejorative term, but department and agency attorneys and members don't have the ability to rewrite the law to make it say what they'd like it to say. And if we get away from that principle, we've eroded respect for law and the whole constitutional structure where Congress makes the laws, not the executive branch.
What about in the context of litigation, where you're litigating a case involving one of these guidance documents and you're representing the federal agency in question? Will the department, under your leadership, assuming you're confirmed to this position, ask courts to defer to non-binding guidance documents in the same way that courts are routinely asked to defer to regulations?
Well, that's a good question from a good lawyer, I have to say. In other words, the question you're suggesting is the established law of the land or the courts is that they give certain deference to well-established, properly established regulations issued pursuant to statute. But what if the secretary just issues a guidance document? Is the court entitled to give full deference to that? I would. First of all, I don't know. I haven't researched it. But I do think that would be a pretty bold step to go that far and would be dubious about it.
Thank you. As you know, from time to time, the Department of Justice receives subpoenas, or one of the entities being represented by the Department of Justice might receive requests from members of Congress, from committees in Congress, including some committees that have the power to issue subpoenas, in other instances just letters or other types of requests from Congress for documents. I suspect that there may be a number of outstanding requests of this nature that are left pending at the end of this administration. Requests that were issued during the 114th Congress, the Congress previous to this one, but that will still need to be handled within the department after you're confirmed, assuming you are confirmed. Will you commit to reviewing any of those that remain pending and doing so in a manner that's timely and showing the respect for a coordinate branch of government?
Senator Lee, if you would, repeat for me but kind of...
yeah, pending requests for documents that might be left over from the previous Congress.
Requests for documents in what kind of proceeding?
Requests for documents either from the department itself or in matters where the department is involved representing an entity within the federal government. I just want to make sure that those don't get left behind, that they don't get ignored simply because they haven't been dealt with by the previous administration.
Well, I do think they're entitled to be evaluated, and proper requests, I would assume, would continue to be valid, and we would try to follow whatever the law requires in that regard.
Thank you. I appreciate that. I want to talk about the use of the attorney-client privilege by members of the executive branch, by executive branch officials. In a 1998 opinion, the U.S. Court of Appeals for the D.C. Circuit reached the conclusion that executive branch officials do not enjoy the same common law attorney-client privilege as ordinary lawyers, lawyers who are not executive branch officials. And then Justice Scalia, while he was serving as the Assistant Attorney General over the Office of Legal Counsel, authored a legal opinion stating that executive branch officials do not enjoy the privilege unless they're dispensing with personal legal advice. Instead, in that view, executive branch officials need to exert the executive privilege rather than the traditional common law attorney-client privilege. And yet, executive branch agencies routinely can be observed asserting the attorney-client privilege instead of the in much the same way they would in the traditional context, rather than just invoking the executive privilege. Would you agree with that, that might raise some questions?
Senator Lee, I've not studied that opinion of Justice Scalia. I would be reluctant to comment, except I would say that it's probably good for the American Republic that department and agency officials seek legal advice before they act. In the long run, that's probably better. And I think having some expectation that they can have a candid comment with their attorney is of value. I hadn't thought about and never given study to the question of whether it should be on the executive privilege or attorney-client, although I can imagine the difficulties.
Yes. No, I appreciate your candor on that point, and it gives me some comfort knowing that you're aware of the situation. You'll look at those. I'd like to talk about some antitrust issues in the moments I have remaining, and then perhaps we'll get back to these during a subsequent round. Antitrust regulators, when they're reviewing potentially anti-competitive harms that might arise as a result of a merger, will sometimes impose conditions on the merger moving forward, saying unless you do A, B, and C, this merger can't go forward, but if you do A, B, and C, in order to address whatever concerns we, the antitrust regulators, have, then the merger can be consummated. It is my view that there is a temptation for antitrust regulators sometimes to impose conditions that don't involve anti-competitive concerns, and that raises some red flags, that because the role of the antitrust regulator is to look out for anti-competitive concerns arising out of the merger, that's where their inquiry ought to be focused, and that's where their conditions ought to be focused. Do you disagree with that?
I would agree with that, as you formulated, I believe, and it would be wrong to further some other separate, discrete agenda that's not reasonably connected to the merger itself. So I think we should ensure that we have the highest integrity in antitrust adjudications because they can have great impact. The law is not crystal clear about what's lawful and what's not lawful and what the antitrust division is required to do, and it leaves dangers of, if not politicalization of it, it remains dangers of policy agendas getting embroiled in it. So important division. It requires great integrity and ability, I believe, in the leadership at the Antitrust Division.
Thank you. Just a moment. Senator Leahy.
Thank you, Mr. Chairman. I listened to Senator Lee asking these questions. It occurred to me that you were one of a very, very, very small minority of members who opposed the USA Freedom Act that I drafted with Senator Lee. It passed with a supermajority in both the House and the Senate. Even though you voted against it, and this, of course, stopped the bulk collection by NSA that both Senator Lee and I oppose, do you agree the executive branch has to follow the law that they cannot reinstate the bulk collection of America's phone records without amending federal statutes?
Senator Leahy, that appears to be so, and I can't swear that that's absolutely, totally always true, but it appears to be so.
Wait a minute. We either passed the law or we didn't pass the law. Supermajority voted for the Lee-Leahy law. The president signed into law. You voted against it. Will you oppose the law?
I will follow the law, yes, sir.
And will you commit you're not going to allow the NSA to gauge in the bulk collection of Americans' records in violation of the USA Freedom Act based on a theory that somehow whoever is president has the power to disregard the statute?
I do not believe that the statute can be disregarded, and it should be followed.
Thank you. I appreciate that. We had a dust-up in the press. As you recall, when Mr. Trump bragged about how he had grabbed women and so on, you, shortly after the tape came out, and I realize there's an explanation here, you said, I don't characterize that as sexual assault. But then you said later, the weekly standards characterization of comments I made following Sunday's presidential debate is completely inaccurate. My hesitation is based solely on confusion of the contents of the 2005 tape, the hypothetical posed by the reporter, which was asked in a chaotic post-debate environment. Of course, it is crystal clear that assault is unacceptable. I would never intentionally suggest otherwise. That's basically what you said after the confusion on your first comment. Is that correct?
I believe that's correct.
Thank you. Is grabbing a woman by her genitals without consent, is that sexual assault?
Clearly, it would be.
Thank you. If a sitting president or any other high federal official was accused of committing what the president-elect described in a context in which it could be federally prosecuted, would you be able to prosecute and investigate?
The president is subject to certain lawful restrictions, and they would be required to be applied by the appropriate law enforcement official if appropriate, yes.
And the conduct described, based on the description, would be sexual assault?
Well, the confusion about the question was a hypothetical question, and it related to what was said on the tape. I did not remember at the time whether this was suggested to be an unaccepted, unwanted, would certainly meet the definition. If that's what the tape said, then that would be...
My question is very simple. Is grabbing a woman by her genitals without consent, is that sexual assault?
Yes.
Thank you. Now, You were asked earlier about having called the NAACP and the ACLU un-American. You said that was before you were a senator. But as a senator, you have continued to be hostile to them. You criticize nominees for having what you call ACLU DNA. Now, I remember when Republicans led the Justice Department, as Inspector General found the Bush administration engaged in unlawful, politicized hiring practices. That's the Republican administration's own Inspector General. They said the Ashcroft Justice Department used litmus tests whether applicants would be sufficiently conservative. If they're ever in the ACLU, they couldn't have a job. You said in a radio interview, justice has to be saved from secular, progressive liberals. Okay, let me ask you a couple of simple questions. Are an individual's religious beliefs relevant to their employment at the Justice Department?
Not unless it's such that they can't perform their duties in an honorable way consistent with the law.
What would be an example of that?
Well, if an individual so strongly believed that abortion should be unlawful that they use their position to block constitutionally approved abortions, I think that would make them not subject to being employed in the Department of Justice.
Are you going to have a litmus test at the Department of Justice for people who have worked at civil rights organizations?
No.
Senator Graham mentioned you've long been a champion of states' rights, and certainly you and I have had enough discussions on that, and I realize those are deeply held beliefs. But states have also voted on an issue of marijuana and regulation. I believe your own state of Alabama permits the use of a derivative of marijuana known as CBD oil, legal in Alabama, illegal under federal law. If you are confirmed as the nation's chief law enforcement official, and you know that we have very, very limited federal resources. In fact, we're spending about a third of our budget now just to keep the prisons open because of mandatory minimums and whatnot. Would you use our federal resources to investigate and prosecute sick people who are using marijuana in accordance with their state laws, even though it might violate federal law?
Well, I won't commit to never enforcing federal law, Senator Leahy, but absolutely it's a problem of resources for the federal government. The Department of Justice under Lynch and Holder set forth some policies that they thought were appropriate to define what cases should be prosecuted in states that have legalized, at least in some fashion, some parts of
Do you agree with those guidelines?
I think some of them are truly valuable in evaluating cases, but fundamentally, the criticism I think that was legitimate is that they may not have been followed. Using good judgment about how to handle these cases will be a responsibility of mine. I know it won't be an easy decision, but I will try to do my duty in a fair and just way.
The only reason I mention it, you've been some very strong views. You even mandated the death penalty for anyone convicted of a second drug trafficking offense, including marijuana, even though mandatory death penalties are, of course, unconstitutional.
Well, I'm not sure under what circumstances I said that, but I don't think that sounds like something I would normally say. We're glad to look at it,
Would you say that's not your view today?
It is not my view today.
Thank you very much. Thank you.
I perked up when he started talking about federalism. And, of course, everything Senator Leahy said was interesting, but the federalism stuff is particularly interesting.
Praising your legislation.
Yes, exactly. I appreciated that, too. That was great. Federalism is an issue that's near and dear to many of us, and I know it's important to you. The notion that Our federal government possesses powers that James Madison described as few and defined. Those reserved to the states are numerous and indefinite. We were supposed to be a different legislative body. Our federal government was always intended as a limited purpose national government, not a general purpose national government, one possessing complete police powers. We've seen a slow but steady drift over the last 80 years away from this principle of federalism, such that powers exercised at the federal level today could no longer be described as few and defined, but more appropriately described as numerous and indefinite. And in light of the supremacy clause in the Constitution, any powers we do exercise through the federal government are by definition replaced from the states. In other words, when our action conflicts with state action, it's our action that prevails in light of the supremacy clause. It's one of the reasons why federalism needs to be looked out for so carefully. One of the reasons why a view that I think you and I both share is that U.S. government officials in all three branches of government, whether they wear a black robe or not, are expected when they swear an oath to uphold the Constitution to look out for basic structural protections in the Constitution like federalism, so that we don't have an excessive accumulation of power in the hands of the few. So the Founding Fathers set up this system in which we have these structural protections. We have the vertical protection we call federalism, which we've just described, and the horizontal protection we call separation of powers. It says within the federal government, in order to protect us against the risks associated with the excessive accumulation of power in the hands of the few, we're going to have one branch that makes the laws, another branch that enforces the laws, and a third branch that interprets the laws. As long as we keep each branch within the same lane, the people are protected from what happens when one person or a group of people gets too powerful. But over the last 80 years, just as we've seen a deterioration of federalism, we've also seen a deterioration of separation of powers. You have an interesting set of circumstances with our laws, our controlled substances laws concerning marijuana, in that for the first time in a very long time, you've seen some attention paid to federalism, but in the limited area associated with marijuana. In other words, there are federal laws prohibiting the use of marijuana, the sale of marijuana, the production of marijuana, that apply regardless of whether a state has independently criminalized that drug, as every state until recently had. Then you had some states coming along and decriminalizing it, sometimes in the medical context, other times in a broader context. The response by the Department of Justice during the Obama administration has been interesting, and it's been different than it has in other areas. They've been slow to recognize principles of federalism elsewhere. They chose to recognize it here. My question to you is, did the way they respond to that federalism concern run afoul of separation of powers? Did the department's approach to this issue that they identified as a federalism issue contravene the understanding that we are the lawmaking body, the executive branch is the law enforcing body?
Well, I'm not sure I fully understand the point of your question, but you're talking about separation of powers within the federal government, the
Yes.
three branches of federal government.
Yes.
And how does that implicate the marijuana laws?
Yes. Are there separation of powers concerns arising out of the Department of Justice's current approach to state marijuana laws?
Well, I think one obvious concern is that the United States Congress has made the possession of marijuana in every state and distribution of it an illegal act. So if that's something is not desired any longer, Congress should pass a law to change the rule. It's not so much the Attorney General's job to decide what laws to enforce. We should do our job and enforce laws effectively as we're able.
Thank you. I'd like to get back to antitrust issues for a moment. In 2010, you co-sponsored some legislation that extended the Antitrust Division's leniency program, and it extended it all the way out to 2020. So it was a 10-year extension at the time. You helped move that through. The legislation provided that members of a cartel could receive reduced penalties if they reported cartel activity to the department and cooperated with any investigation the department had in connection with that antitrust cartel. Now, the Antitrust Division within the Department of Justice considers this tool, quote, its most important investigative tool for detecting cartel activity, close quote, because it creates an incentive for cartel members to self-report, to come forward and to identify things that the Antitrust Division needs to be aware of. So I applaud your leadership in this area because it's been very helpful to the enforcement of our antitrust laws of the department. So I have two questions related to this program looking forward. First, given its importance, do you think the program should be made permanent? And second, are you open to any other ideas that might strengthen the program?
Senator Lee, I would not commit to you that I have formed an opinion on that. These are very complex areas of the law. I'm not a member of the Antitrust Subcommittee, as a number of members of our committee are, and have achieved levels of expertise like Senator Klobuchar and you and others. So I would just have to commit to you that I'm open to hearing the views of this Congress and that subcommittee, and would try to work with you. But I do understand that antitrust policy is an important issue for America, and we need to get it right, and that will be my goal.
Thank you. One important question that sometimes arises in the antitrust context relates to what role the Department of Justice should play in communicating with foreign authorities, authorities in other countries that deal with competition laws, deal with things analogous to our antitrust laws in this country. The Department of Justice has typically played a leading role, but in recent years it has also allowed the Federal Trade Commission, the FTC, to become heavily involved. To my mind, this raises some potential concerns because the FTC is an independent agency. As compared to the Department of Justice, of course, which is headed by a presidential appointee who, with Senate confirmation, serves at the pleasure of the President. Do you have any opinion on this, that this point that the Department of Justice, which is more accountable to the President and therefore has some connection to the people, should be more actively involved in communicating with foreign antitrust or competition authorities?
I really wouldn't attempt to comment today on that. I would be glad to hear your thoughts on it. I think it can be problematic if U.S. officials encourage foreign officials to join with them against an action of a private company that could put so much excessive pressure on them that they're not able to resist, and when they may have a lawful basis to resist. So these are big issues, and you have to be sensitive to the power that the Department of Justice has, the Antitrust Division has, and make sure that there's a principled policy and lawful basis for what is done.
Thank you, Senator Sessions. I see our chairman's back. Oh, he's not back. Senator Feinstein.
It's my understanding that Senator Durbin has not yet had its second round, and so I would like to defer to him.
No, you. Senator Cannon. Oh,
I'm going to defer to Durbin because he somehow got missed.
Thank you very much. I want to thank the chairman and my friend Senator Feinstein. This morning, before the Senate Intelligence Committee, Director Comey of the FBI was testifying on the question of investigating the Russian involvement in this last election. And he was asked if there was any ongoing investigation about contacts between Moscow, the Russians, and any presidential campaigns. And he refused to answer, said he wasn't going to discuss any ongoing investigations publicly. I would like to ask you a question related to recusal. You stated earlier today that you had made the decision, and you haven't given us a real background on it, but made the decision that you would recuse yourself from any prosecutions involving Hillary Clinton or the Clinton campaign and emails. And then I understand, I wasn't present, but Senator Blumenthal asked you for some other hypotheticals as to whether you'd recuse yourself on an emolument question or some other things, and you said you'd take it on a case-by-case basis. What if, the hypothetical, same as Hillary Clinton, we are dealing with an investigation that involves the Trump campaign or anyone in the Trump campaign? Would you recuse yourself as Attorney General from that prosecution?
Well, my response to my recusal issue was because I'd made public comments about it that could be construed as having an opinion on the final judgment that would have to be rendered. I don't think I made any comments on this issue that go to that, but I would review it and try to do the right thing as to whether or not it should stay within the jurisdiction of the Attorney General or not.
It would strike me that this is an obvious case for a special prosecutor if it involves a campaign leading to a candidate who selected you as the Attorney General. Wouldn't an abundance of caution suggest that you wouldn't want any questions raised about your integrity in that type of prosecution?
Senator Durbin, I think it would be incumbent upon anybody who's holding the office of Attorney General at that time to carefully think his way through that, to seek the advice, and to follow the normal or appropriate special prosecutor standards. And so I would intend to do that, but I have not expressed an opinion on the merits of those issues to my knowledge.
Senator Sessions, there's been a lot of controversy about refugees. The United States had a dubious record on refugees during World War II, refusing to accept Jewish refugees who were then, in some cases, returned to Europe and the Holocaust and perished. After World War II, a new policy emerged in the United States, a bipartisan policy, and the United States became more open, in some cases generous, to accepting refugees. The numbers, I've heard various numbers, but 650,000 Cuban refugees who came to the United States during the ascendancy of the Castro regime, 125,000 or more Soviet Jews accepted in the United States, spared from persecution in the Soviet Union, 400,000 from Eastern Europe after World War II, 400,000 from Vietnam, 150,000 from the former Yugoslavia. In the audience today is Omar al-Muqdad. I don't know if he could please stand here. Mr. Muqdad is a Syrian refugee. His story is a story of a journalist who for more than a decade publicized human rights abuses by the Assad regime, arrested 7 times, imprisoned for 2 years. When he refused to stop writing after that, the prison guards broke his hands. After his release from prison, he continued to write about the abuses of the Syrian security forces. When he was again pursued by the regime, he fled to Turkey. He was resettled in the United States by Catholic Charities after receiving refugee status. There have been some strong words spoken about Syrian refugees. In fact, during the course of the campaign, there were some who said we should accept none, and many who've questioned whether we should accept any refugees from anywhere. Despite the lengthy vetting process and background checks, some have said, no refugees, we're finished with that business. One of your responsibilities as Attorney General will be the involvement of prosecutorial discretion, decisions that have to be made about the fate of men like Alton Mills I introduced earlier, who had served 22 years of a life sentence for the possession of crack cocaine. Cases of Oscar Vasquez, a man who was a dreamer and wanted to serve the United States in uniform, and this case involving Omar al-Muqdad. The American Bar Association standards say the duty of a prosecutor is to seek justice, not merely to convict. It is an important function of the prosecutor to seek to reform and improve the administration of criminal justice. When it comes to cases like these, in your role as the leading prosecutor in the United States of America, what is your feeling about your discretion to make the decision as to whether or not to spare individuals like those I've described?
I've been made aware in the last several years how this process works. It's really the Secretary of State, usually through consultation with the President, that decides how many refugees should be admitted to the country. And there's little Congress can do other than getting into a funding argument with the President about that. So Secretary Kerry met with members of the Judiciary Committee to announce what he planned to do on refugees. That will be how it would be decided, and legally the President appears to have that power, but it would be my responsibility, I think, to make sure that it was exercised within the bounds of law.
But you have a responsibility too. You oversee the Office of the Pardon Attorney, which recommends that sentences like those of Alton Mills be commuted. You oversee the immigration courts, which are responsible for interpreting how our nation's immigration laws apply to dreamers and refugees like Mr. Muqdad. So this isn't another agency, it is the Department of Justice, and you will be the leader of that department. You will have the authority and prosecutorial discretion. You can't point to Congress and you can't point to the State Department. There's a responsibility within your own department.
Well, a refugee is admitted or not admitted to the United States on the approval or disapproval by the Secretary of State and its consular officials. It's not a trial or not a litigation. So that's how that would be determined. The gentleman from Syria that you mentioned should have be able to make a strong case for his acceptance as a refugee because he's been damaged and injured and attacked and at risk for his writings. So that would give him a more, proving that should give them, put him at a higher level of potential acceptance.
Well, you and I can disagree on this one point in your authority over immigration courts as Attorney General, but I hope that we both agree that there are compelling cases of people who are victims around the world of terrorism and war, discrimination and maltreatment, men and women, and many of them look to the United States as the last possible place for them to find safety and security. I hope after the heated language of this last election campaign that we can come back to some of the standards that have guided this nation since World War II.
Well, we'll not end the refugee program. I would not favor that, but we do have a responsibility to be careful and make sure those who are admitted have been properly vetted and are not a danger.
Thank you.
This is what I'd like to do. The votes kind of made this a convoluted rounds that we're in here. One person's had third round, we got one person with no round. So this, or not without his first round. And then Senator Sessions would like to take a break. So here's what I'd like to do, Senator Sessions, is okay with you. I want to go with Senator Hatch, Senator Feinstein for their second rounds, and then Senator Kennedy for his first round, and give you a short break at that point. Is that okay?
That would be good.
Okay,
Thank you.
And for the benefit of the rest of you, I kind of got lost out of this, but I've got to be here for the rest of the meeting where maybe some of you don't have to be. So I'll wait and do my second, third, and fourth round when everybody else is gone.
Oh, is that nice?
How many?
Okay. Now it's Senator...
I think it's Hatch.
Senator Hatch, yes.
Senator Sessions, I think you've done a terrific job. I've known you all your 20 years. I've watched you work diligently on the Judiciary Committee and on your other committees as well. You're an honest, decent man, and you have tremendous abilities in law enforcement. And you've proven it here today, and you're showing it here today. It's hard for me to understand why anybody would be against you. But let me ask just a couple of questions. I want to emphasize that you have wide support for your appointment among law enforcement, including the National Sheriff's Association, National District Attorneys Association, the National Association of Police Organizations, National Association of Assistant U.S. Attorneys, National Narcotic Officers Association, the Fraternal Order of Police, the Federal Law Enforcement Officer Association, the International Union of Police Associations, and the associations of major county sheriffs and major city chiefs of police. I'm not sure I've seen anybody that had all that kind of massive support for this position. Now, I draw attention to this for an important reason. Disagreement about political or policy positions are one thing, but accusations about your commitment to fairness or suggestions that you're not sensitive to race is another. Would these law enforcement organizations enthusiastically support someone who was biased? We know they wouldn't. Of course not. Would they endorse someone who would fail to be impartial? Of course not. Such accusations, especially without any evidence to support them whatsoever, are not simply attacks on Senator Sessions. They are also smears against organizations like these, which have similarly examined the record and found Senator Sessions worthy of support. So I'm grateful to you and for your willingness to take this on, knowing that you might be smeared by certain organizations. It takes some guts to do this, but we all know you have guts. We all know that you believe in what you're doing. We all know that you have a tremendous integrity. We all know that you have a tremendous intellectual ability as well. And even though you and I have disagreed on some issues that are important to both of us, you've always acted with distinction and with fairness and decency. And I would expect you to do the same thing as Attorney General of the United States. One thing I know, you would be giving it everything you have. And that's a lot. You have a lot to give. Let me just say, this morning, one of my Democratic colleagues said that the standards for evaluating your nomination is whether you will, quote, enforce the law fairly, evenly, without personal bias, unquote. Do you agree that the Attorney General has a duty to do that?
That's a core responsibility of the Attorney General, absolutely.
And I have no doubt, knowing you, that you'll live up to that. No doubt whatsoever. I think everybody should have to agree with that. The real question is how we can be confident that you will fulfill that responsibility. And most of the questions this morning were about statements you made, positions you took, or votes you cast as a senator on legislative issues. And some of these questions suggested that you could not enforce a law you had not voted for, or that you would not enforce a law or policy that you might have questioned or personally disagreed with. Now, I personally categorically reject that, and you have too. Am I right?
That is correct.
You're darn right it is. Some of my friends would also reject the suggestion that a liberal could not be impartial. I think liberals can be impartial.
I do too, Senator Hatch. And some people, I don't think it would be hard for me to be impartial and to enforce laws that I didn't vote for. I just don't think that's going to be I think I can separate my personal votes of maybe years ago from what my responsibility is today. And I hope that my colleagues can believe that.
Well, the answer to the question whether you can, as Attorney General, enforce the laws fairly, evenly, and without personal bias, it's a resounding yes, you can. And anybody who disagrees with that hasn't been listening, hasn't observed you over the last 20 years, or any time over the last 20 years. There's not a shred of evidence from your entire record to undermine that conclusion. Now, does the fact that you have already served in both the executive and legislative branches strengthen even further your commitment to the duty of fairness and impartiality? Seems to me it does. Am I right?
Well, thank you, yes. I do believe that I've conducted myself according to principles that I think are valid and try to be consistent and honest in my evaluation of the many complex issues that we have here. Sometimes good people can certainly disagree on them.
Anybody who knows you knows that that's true. Now, the Justice Department has a duty to defend in court the laws enacted by Congress. As a member of this committee for 20 years, you had heard Attorney General nominees profess their commitment to fulfill that duty regardless of politics. Now, in my opinion, the Justice Department under the outgoing administration reneged on its duty to do so in a number of respects. In some key instances, they made decisions on political rather than legal grounds. How important is it for the Justice Department to defend Congress's statutes? And will you commit to do so even when, as a legislator, you would have opposed those statutes?
Senator Hatch, you've been through these issues for many years, and I certainly respect your judgment. But I do believe that the lawyer for Congress, the lawyer for the United States that represents the United States government in court should be the lawyer that defends an act lawfully passed in Congress wherever it's reasonable, a reasonable argument can be made, and I commit to you I will do that.
Well, I believe you, and I know that's true. And I have a rough time seeing why anybody would find any real flaws or fault with your nomination. I just want to personally thank you for being willing to go through this, for your willingness to be able to do this, and for your integrity that you have shown and exhibited and demonstrated over the last 20 years. I can personally testify about you and about what a fine, really good person you are. And we've differed on some pretty important issues from time to time. I have respect for you because you stand up for what you believe, however wrong you may have been. And no, just kidding.
I heard my wife laugh at that.
Well, I have a lot of respect for you, and I hope that the rest of this proceeding goes really well and that we can get you confirmed as soon as possible, because I know you'll do a terrific job, and I'm very proud of you for being willing to accept this. Thanks, Mr. Chairman.
I'm honored to have your support, Senator Hatch.
Thank you. You have it.
Senator Feinstein.
Thanks very much, Mr. Chairman. Just to begin, I would like to ask unanimous consent that all statements and written testimony sent to the committee concerning Senator Sessions be made part of the record, and I have some testimonies and letters.
Without objection, so ordered.
Thank you very much. Senator Sessions, when I was a small child, it was during World War II, and my father took me to a racetrack south of San Francisco called Tanforan, and it had become a detention camp for Japanese American citizens. And during the length of World War II, well, thousands of families were held in this compound. And we checked with CRS, who says no Japanese American was ever convicted of any sabotage against the United States during that period of time. Senator Lee, Senator Cruz, and I have tried together to enact a bill to assure that no American citizen or lawful permanent resident detained in the United States can be held indefinitely without charge or trial pursuant to authorization of military force. So here's the question. Do you believe that the government can, pursuant to a general authorization to use military force, indefinitely detain Americans in the United States without charge or trial?
Senator Feinstein, that's an important question. Classically, the answer is yes. Classically, if you captured a German soldier, they could be held until the war ended. That was done, I'm sure, at the Civil War and most wars since.
I'm talking about
an
American.
So then the question is, we're in a war like we have now that's gone on multiple years, and I would think the principle of law certainly would appear to be valid, but as reality dawns on us, and wars might be even longer, you know, it's honest to discuss those issues. So I respect your willingness to think about that and what we should do. But in general, I do believe, as Senator Graham has argued forcefully and for many years, that we are in a war. And when members who, unlike the Japanese, who were never proven to be associated with a military regime like the Japanese government, these individuals would have to be proven to be connected to a enemy, a designated enemy of the United States. So I probably explained more than I should, but that's basically the arguments and the issues we're facing. I respect your concerns, and I'm sure they will continue to be debated in the future.
Well, let me just say a few things about that. I've served on the Intelligence Committee for 15 years. I read all of it. I think I know as much as anybody about what's happening in the United States. And this is not, these are Americans that we're talking about. They can be picked up and detained and held without
You're talking about Americans
of trial indefinitely. And that should not be the case.
Well, I understand your point, and a citizen of the United States has certain important rights. They cannot be abrogated. It is absolutely so. They cannot be detained without undergoing a habeas review, and the government surely has to prove that they are indeed connected sufficiently with an enemy action against the United States, so they couldn't be detained. And
well, I appreciate that. Let me go on to another subject. You were one of 9 senators to vote against the Detainee Treatment Act of 2005. It prohibited the imposition of cruel, inhuman, or degrading treatment or punishment of any person in the custody or control of U.S. personnel. You also voted against an amendment sponsored by Senator McCain in the 2016 Defense Authorization Bill to limit interrogations to the techniques provided by the Army Field Manual, which does not include waterboarding. Do you agree that the CIA's former enhanced interrogation techniques, including waterboarding, are prohibited by this provision of law as now codified at 42 U.S.C. 2000 DD?
It does appear to be clear that the last act, the McCain Amendment, would prohibit waterboarding.
And you would enforce that?
I would force the law, yes.
Thank you very much. Now, my third question is, and this was in the Washington Post, a report last night that you failed to disclose to this committee and to the Office of Government Ethics subsurface rights to oil or other minerals on more than 600 acres in your home state, some of which, I gather, are adjacent to a federal wildlife preserve. Apparently, Alabama records, and this is a quote, show that the senator leased undivided mineral interests to Chief Capital, a Texas firm, in 2015. Do you, in fact, own these interests?
Senator Feinstein, I believe that's so. And the way it happened was that many years ago, at least 50 or more years ago, my family, ancestors, sold some land and reserved mineral rights. Later, there was a dam built on the river and a desire to take land that were going to be flooded and to add additional land for a duck preserve. And they negotiated, and the family sold land to the government and retain the mineral rights per the agreement. At least that's my understanding. So by an odd series of events, the properties fell to me. I've never reviewed the deeds. I've never known how much land is out there that I own mineral rights on, although oil companies are pretty good about making sure they contact real owners before they drill a well. So you're correct that we reported the income on my return as coming from the property that I own and the property where the oil well is. I did not note in that report specifically that it was all income because the blank said royalties, but maybe I'm there. So I would just say to you this. We absolutely had, this is something I've taken no affirmative action in. It's something I'm going to take affirmative action in. I have one of the simplest clearest, fairest financial reports you can see. My assets and my wife's assets are almost entirely Vanguard funds and municipal bonds. I own no individual stocks because I want to be sure that I don't have conflicts of interest. I want to adhere to high standards. We're going to find out what we did or didn't do and correct it.
Good. Thank you.
I welcome brand-new Senator Kennedy, not only to this committee, but to the Senate as well. Senator Kennedy, you're allowed 10 minutes now.
Good afternoon, Senator.
Thank you.
My name is John Kennedy, and that's really my name. Just so you'll know, I used to have a law partner named Jose Canseco.
Oh, is that interesting?
Would caused a lot of confusion when we'd go to meetings together.
I guess.
I have been impressed in preparing for the hearings with the deep support you enjoy from law enforcement. In fact, one of my sheriffs from Louisiana, I don't know if Greg is still here, Sheriff Greg Champon, who also happens to be a lawyer, came all the way up from Louisiana to lobby other senators on your behalf. And I've noticed that a lot of the organizations that are supporting you are organizations that have not always agreed with your positions on the issues. And that impressed me. I just wanted to read you one quick excerpt. This is from a statement by the Sergeants Benevolent Association from the NYPD, New York, about as far away from Mobile as you can get. This is what the letter said. Quote, as a union representing law enforcement officers over the years, the SBA, that's the Sergeants Benevolent Association, has worked as both an ally and a respectful opponent of Senator Sessions. This experience has shown us that Senator Sessions is a man of unquestionable integrity, devoted to the rule of law and the best interests of our nation. It's for these reasons and many others that we believe Senator Sessions is the absolute right choice to serve as America's chief law enforcement officer. Now that impressed me. I'd like to know what you intend as Attorney General to do to further partner with state and local law enforcement.
That is so important. And the United States attorneys throughout the country, as in Louisiana and Alabama, are key players in this. All United States attorneys' colleagues are funded to have law enforcement coordinating officers. I had two in my small office. We had regular meetings. In the early 80s, this is when it started. This is when the first time. And so instead of having a law enforcement plan produced in Washington, D.C., the U.S. attorneys were directed to get all the federal agencies and all the state and local agencies to sit down and identify what their main threats are and to direct their resources to deal with these real threats in that district, and they would be different in different districts around the country. I sense that that's been eroded somewhat, so we need to go back to a lot of that. The Department of Justice has great resources for identifying tactics and strategies that work on crime. We ought to be able to always help the state and local police officers have the best data on what works and how to create safer and better communities. The federal government cannot dictate to these agencies. It would be a disaster. They wouldn't accept it, number one, and any influence you might have would be eliminated. We need to be partners. The federal government, through its power internationally and nationally, can help a local investigative agency solve a complex criminal case that they don't have the subpoena power, or they don't have a Louisiana U.S. attorney or a sheriff doesn't have power to have investigations conducted in Texas or Denver. So these are the things that are all important. And I truly believe that from a matter of public policy, we need to see the big picture. And we're all in it together. We're all in it together. And 90% of the law officers in America are state and local. And they're the ones that are the eyes and ears of law enforcement. So I really think, Senator Kennedy, you're correct that we need to do this. I think there's a feeling among law enforcement that that's not been happening sufficiently.
I think you're right, Senator.
And I sense that that's one of and the fact that I think I understand that I've had as much strong and enthusiastic support as I've had.
You know, when a radical Islamist terrorist drives a truck into a group of people and kills them, we're told that we should not judge all Muslims by the act of a few. And I agree with that. Don't you think the same rule ought to apply when one or two law enforcement officers make a mistake? Don't you think that same rule ought to apply to all the other 99.9% law enforcement officials out there who just get up every day and go to work and try to protect us?
Well, I really do. And I think those of us in high public office do need to be cautious about demeaning whole departments and whole groups of people, because within those, most any departments you can find in America, surely most of the people are just wonderful servants, public servants trying to do the right thing. So when we say these things, we can increase risk for them. We can make it harder for them to have relationships with the constituents where they're serving, and actually result in an increase in crime and ineffectiveness in law enforcement. So, boy, these issues we can't miss these issues. Yeah. You cannot make big mistakes like we may be making now. And so I commit to doing my best as a law officer to engender the kind of unity and comprehensive effort, state, local, federal, that would be the most effective engine to fight crime and make our communities safer.
In Louisiana, Senator, we believe that love is the answer, but we also believe that we have the right under the Constitution to own a gun just in case. Could you share with me your thoughts on the Second Amendment?
Well, I do believe the Second Amendment is a personal right. It's a historic right of the American people, and the Constitution protects it and explicitly states it. It's just as much a part of the Constitution as any of the other great rights and liberties that we value. So my record is pretty clear on that. However, if people can forfeit their right to have a gun, and it can be a factor in receiving sentences and being prosecuted if you carry a gun, for example, during the commission of a crime. That can add penalty and convictions to you. I think that's a legitimate and responsible restraint on the Second Amendment right to keep and bear arms.
I think they believe this in Alabama too, but in Louisiana we also believe that nothing makes it easier to resist temptation than a good upbringing, a strong set of values, and witnesses. I'd like to know your thoughts on the Freedom of Information Act.
Well, the Freedom of Information Act is law, and I would say it's carried out, and the policies of the country need to be followed.
Okay. I've got one final question. I read the Inspector General's report about the Department of Justice. I think it came out in about the middle of 2016 last year. The Inspector General talked about problems with the department's massive grant programs. And the Inspector General said that approximately $100 million over the last 5 years went for, quote, questionable expenditures, or funds that, quote, could have been put to better use. Now, this is taxpayer money. It didn't just fall from heaven. We thank heaven for it, but it came out of people's pockets. I'd like to know your thoughts about the IG report, if you're familiar with it, and what you plan to do once you're confirmed, and I believe you will be confirmed, to help our friends at the Justice Department prioritize their spending a little bit.
Thank you, Senator Kennedy. That report raises real concerns. I believe that any responsible public official should recognize that when they obtain an IG, their own Inspector General, and saying that their department is not performing according to high standards, should listen to that report and take action and review what's happening and make sure it does not continue. The American people have no desire, and they absolutely should not, have their money sent to Washington and then be wasted. We can do a lot more with the money that we have, having been ranking member of the Budget Committee, and I know that how difficult it is, but one way to get extra money, free money, is to use the money you've got wisely for things that are valuable.
Senator, I don't know you well, but I've followed your career with respect and admiration for a lot of years, and I just wanted to tell you that. You're going to be a great Attorney General.
Thank you. Thank you very much.
Senator Sessions, you asked for a short break, so I hope maybe 15 minutes would be adequate.
That would be adequate, absolutely.
Just because I came back, he's wants
Senator Whitehouse is going to be next.
No, that's okay.
Yeah. So when he comes back, yes, go ahead, Senator, take your time. We'll stand in recess.